Alberta's oil and gas liability management system has become a really hot topic these days. It was brought to the fore by the orphan well problem, and which is basically now thousands of wells that have been left behind by bankrupt companies, failing companies, and environmental liabilities have had to be assumed by the Orphan Well Association. But there's something else going on, and that is the reform of that system is kind of a bumpy road. And we're going to be talking to Professor Drew Yemchuk at the University of Calgary about that. He wrote an ABLAWG post, came out today. So welcome to the interview, Drew.
Thank you. I think professor is actually inaccurate. I'm a sessional instructor there and the staff lawyer at the Public Interest Law Clinic, but thank you.
Well, thanks for clarifying that. So why don't we, this is a fairly complex topic, so why don't we start with a brief overview of your post, if you don't mind.
Since the early part of the Redwater decision, what became the Orphan Well decision at the Supreme Court, it's been pretty evident that there was something wrong with Alberta's liability management system. The system's meant to be very complicated. Part of what it uses is an asset to liability ratio, so that a company who owns oil and gas wells doesn't have to post security for the cleanup of those wells, so long as those wells are worth enough for the wells to themselves be considered security. Now, the huge problem with asset to liability approaches is that if the value of the resource in question, oil, suddenly drops, the security that the province has is oil wells, securing the cleanup of those same oil wells. And that was kind of a known problem since at least 2015. I'm not sure when it would have first been identified. And the province has been back and forth talking about how to fix the system since then. And there really hasn't been any public discussion from the Alberta Energy Regulator or Alberta Energy about how they plan to do that. We saw some very, very minor reforms about 5 months ago, expanding the power of the Orphan Well Association, but that's pretty much all we've seen.
Well, and this is a problem, I understand, because the landowners whose land on which many of those wells sit they're pretty upset about the way things have gone. They're not getting their payments. They're worried about environmental liabilities on their property, and yet they are apparently, I gather, not being included in this process, nor are the general public. Is that correct?
Yeah, I think the two groups that get really shut out of this are the rural landowners of Alberta who actually live near all these wells, and the environmental voices who don't seem to get really any discussion at the Alberta Energy Regulator. And both of those people, both of those groups seem like they should have some involvement in this reform system because of how large scale it will be for how these environmental liabilities are handled in the future.
Now, I do report on other jurisdictions, including American ones, where the environmental groups actually do play a constructive role in issues like this, and it's completely absent in Alberta. In fact, those environmental groups are often demonized, as we know. So is this sort of standard operating procedure at the AER to do things behind closed doors, or is it just this particular issue?
I think it's pretty standard. They will consult, it could be the Alberta Energy here, or it could be the AER. Depending on the level they want to reform the system, they might be proposing new legislation, changing regulations, or just issuing AER directives. So without knowing what change they're planning, I can't tell you who's actually running it. But it's pretty ordinary for both Alberta Energy and the Alberta Energy Regulator to meet with industry representatives to figure out what they need to move forward, and try not to indicate to the public ever what happens. Eventually you can get those records through the Freedom of Information Act, but that's not an easy option.
So this seems very, very problematic, especially in 2020 in particular. It would seem to be unacceptable. Is there any recognition that this is a problem with industry, within industry and government and the regulator? Is there any plans afoot to change it?
To replace the liability management system?
Well, to change the process so that it's more transparent and people outside of industry can participate.
No, I haven't heard any movements to open this process up. I'm already surprised at how long it's been taking. I thought, uh, I thought that after Redwater, the system would have been totally replaced within a year or two. And then after the federal government contributed that cash to the Orphan Well Association, the federal government seemed to imply they had come to an agreement with Alberta about how to reform the system. But then again, we've heard nothing. So I'm surprised at how long the process is taking, and given that they're taking so long, that it's been so secretive.
Yeah, I seem to remember it was either the minister or the prime minister mentioned when they announced the money that transparency and greater accountability was something that the federal government was requiring as a condition of giving them the cash.
Yes, I fully thought there had been a deal between the federal government and the provincial government about how this system would be reformed. And it seems like maybe there wasn't. I have no idea.
Well, Drew, thank you very much for this. Really appreciate it. And this is a hot topic, and no doubt we'll be chatting about it again in the near future. Thank you very much.
You're welcome.